Hello friends, I am Dr. Pavandeep Kaur from Khalsa College of Law, Amritsar. The topic of our today's discussion is development of principle of justice, equity and good conscience. Welcome all to today's talk. Dear learners, the present module will make you acquainted with the concept of justice, equity and good conscience, historical perspective of justice, equity and good conscience, specific guidelines for the application of justice, equity and good conscience, the principles of justice, equity and good conscience, application in India, and the role of judiciary and British jurisprudence. Dear students, after going through today's talk, you shall be able to understand the concept of development of principles of justice, equity and good conscience in India. So friends, let's begin with brief overview of today's module. Issues of justice, equity and good conscience first arose in the Impase Regulation Act of 1781. In the absence of statutes or personal laws, Indian courts use a method of settling cases known as equity, justice and good conscience. The ancient Hindu laws had their concepts of justice, equity and good conscience, like its modern counterpart in the Indian legal system. It has its origins in the British Raj in India. The High Court established by the British government stated that where the law is unclear or silent on a matter, the matter will be decided according to the principles of justice, equity and good conscience. Justice, equity and good conscience are often interpreted as a referring to the laws and regulations of England, where no law applies to questions of law. Courts also use equity, justice and good conscience in cases where Hindu law does not exist about personal relationships. Although this concept has a timeless and unchanging universal value, its application must be adapted to the myriad situations where justice is required, like purposive interpretations designed to correct possible situations that the legislature cannot clearly understand. Justice, equity and good conscience appear to abstractly fill a legal void that requires justice in a situation. Since the human mind can never be replaced by a computer, no law can provide justice in all situations. Yes, the social environment of a particular society may depend on the unchanging values of the old social system, the ideal values of the developing society and the moral and social consciousness represented by the need for justice. Current thinking situations are based on real situations. Thus, British concepts, especially those derived from laws enacted by the state to meet the needs of the state, do not reflect the universal principle of equal justice and conscience, which necessarily require caution when applied in the Indian context. While the ubiquity of high ideas can enlighten anyone, and the principles applied in another real world situation may not be relevant, as mechanical use is dangerous. Further, dear learners, before the discussion of development of principle of justice, equity and good conscience, it is important to know the exact meaning of them. The first one is principle of equity. The term equity is drawn from the Latin word equitas, which means to equalize. There are two main components of the principle of equity. The first one is he who seeks equity must do equity, and the second one is he who comes into equity must come with clean hands. According to DICE, equity aims at three objectives. The first one is the interpretation of law should be based on sound logical reasons. Second one is, there should be generality in the application of law. And the third one is, the deficiencies of law should be removed through equitable principles of justice and good conscience. According to Sir Henry Mann, equity is a set of rules that were in existence side by side with original law and were based on well-established principles of morality, nature, justice, honesty and uprightness. Further, principle of justice. The term justice means which is good for everyone. Suppose we accept something because we can't fight for it, or we can think that since it is the view of the majority, we are bound to follow it, then it is not a justice. According to Sir John Rawls, justice means fairness. He wrote in his book Theory of Justice in 1971 that if equality and freedom can be rightly maintained, then only justice can be maintained. But more particularly in an organized society, the best answer to this question is the concept of justice by the great political philosopher Honorable Sir Plato. Plato said that performance of duty by every person at its allotted station is justice. This is the best concept since it is based on individual and is for an individual. Further, principle of good conscience. Equity and justice are in a macro sense settled principles of law, whereas the principle of good conscience is particularly the discretion and will of the person who is applying this principle. According to Thomas Hobbes and Jean-Jacques Rousseau, men are by nature a rule-following person. He is a moral and intellectual being. Further, if we read the philosophy of all these political philosophers, there is one common thing that they all have emphasized. It is that all of them tried to make a good state for the welfare of the people and said that men are moral beings. Good conscience means the real will of every person if the good conscience is applied for public welfare. Therefore, this concept is best in itself, but it requires a system of checks and balances because the will of an individual can be actuated by the desire of self-gain. Further, dear friends, history of principle of justice, equity and good conscience. In 1780, Bengal first introduced the maxim justice, equity and good conscience. Sir Elijah Impey, the first Chief Justice of the Calcutta High Court, ruled that Mufzil and Sadr Adalat should, in all cases where no specific instructions were given, act according to the principle of equity, justice and good conscience. In theory, this ruling gives all heads of litigation rules for determining penalties, the theoretical legal basis for courts to decide cases that do not have specific statutory norms. Judges are given discretion to adopt any rule or practice them deemed reasonable in the circumstances of the case before them. This principle was applied in legislation, resulting in various laws and many principles of the English language. This principle was gradually introduced in Bombay, Madras and other provinces of India. Dear friends, let us discuss the role of the Privy Council in the implementation of the principles of justice, equity and good conscience. Section 5 of the Central Provinces Laws Act 1875 provides for the introduction of Hindu or Muslim law in civil cases. According to Section 6, the court must act by the principles of justice, equity and good conscience in matters not specified in Section 5. Similarly, the Punjab Laws Act of 1872, the North West Frontier Province Act and Oath Act of 1876 provided the same principle. In case of Muhammad Raza versus Abbas Bandi, the Privy Council held that principle of justice, equity and good conscience had been endorsed as the eventual test in all courts of provinces in India. This principle acted as the residuary source of law when there was no act of parliament, no statute if it is outside the head of Hindu and Islamic law. Dear friends, there are specific guidelines for the application of justice, equity and good conscience. This principle had no definite connotation. It did not mention a specific set of laws, nor did it provide clear guidelines that judges would follow when deciding disputes. In short, it was the judge's discretion. Judges were entirely free to deliver the judgment of the cases brought before them to the best of their capability to ensure substantive justice between the parties involved. This principle required court to decide which law to apply based on reason and justice in each case. This laid the foundation for the judges to rule on case-by-case basis. In a disputed situation, the judges can use principles based on what he believes to be justice and good conscience. Moving further, now I would like to discuss the application of principle of justice in British India. Justice, equity and good conscience. A 1683 charter issued by Charles True provided that East India Company could administer admiralty courts of all kinds, each convened by a judge experienced in civil law, assisted by 2 persons chosen by the company. It was made clear that these tribunals were to decide matters by justice and conscience, as well as the laws and conventions of the merchants class. However, this only applies to a company employees. Another aspect of the current module, which is sometime overlooked in the historical literature, is the revival and inauguration of the Court of Justice on 25th March 1718 by the Governor of Bombay, Charles Boone, which marked a new era in the Bombay's judicial history. The Governor and Council established the court, and company representatives eventually gave their approval. In addition to English judges, the Supreme Court in 1718 had 10 judges, including judges from various Indian communities. The court was peculiar as it had jurisdiction over all civil and criminal cases by the law, equity and conscience. In 1781, Lord Impey's Bengal laws laid the foundation for the Indian concept of equity, justice and conscience, requiring judges to act by the principle of justice, equity and good conscience without special instructions. Later, many such acts, rules were empowering the courts tribunal to act according to the equity, justice and good conscience without specific instructions or provisions of law. Dear friends, the most important aspect of this module is application of justice, equity and good conscience in India. In India, the doctrine of justice, equity and good conscience dates back to the late 18th century when introduced for the first time in the presidencies of Bengal, Bombay and Madras. The doctrine was later introduced in other territories of the India, albeit gradually. The general idea behind this doctrine was that if on a particular point of dispute before the court there was no express law, then court was to decide the matter according to justice, equity and good conscience. The doctrine owes its existence to the reason that in the 18th and 19th centuries, law could not be found on every matter. As the history itself reveals, So, there was a huge vacuum in the legal system and the courts were to act according to justice, equity and good conscience. It can hardly be said that the doctrine is now obsolete in the wake of complete law code governing India. Nor can it be said in the wake of the full-fledged judiciary India has. But before we tread any further, it is important to mention that after the early days of its advent, a new orientation began to be given to the maxim justice, equity and good conscience. That is, the courts started interpreting the maxim to mean English law so far as applicable to the Indian situation. This was visible rather substantiated by two developments in the 19th century. The first was establishment of high courts in 1862, which consisted of the Englishmen as judges, obviously trained in English law. They had a natural bias in favor of the English law, and thus when a dispute came before them to which no local custom was applicable, they invariably began to base their decisions on the English law. The second factor responsible for this new orientation, rather a trend, was the activation of Privy Council as the ultimate court of appeal from India from 1833 onwards. The Privy Council also consisted of English judges, and as a corollary of if they also applied the same English concepts of justice, equity and good conscience. It is in this way the process of reception of English law in India has been stimulated. However, while applying the English law, the touchstone that always remained there was whether it applied to the Indian situation. We can also say that this doctrine in a way acted as a means to incorporate English law. The trend of applying the English law did not stop here. Instead, it continued unabated during the 19th and 20th century so far as relevant to the Indian situation. Thus, the rules of English law continued to find their way into the body of Indian law indirectly through the maxim of justice, equity and good conscience. Even after the independence of India, we find reference is still made to English cases by the Indian courts, sometimes to interpret the Indian statutes and at other times as a residuary source of law whenever need has been felt to decide a case according to justice, equity and good conscience. The broader concept of natural justice, which has now become the hallmark of Indian law, like every other country, is the direct manifestation of the doctrine of justice, equity and good conscience. For the doctrine does not now only mean the English law, rather it is the literal meaning of the words used in important maxim, that is justice, equity and good conscience. The frequent use of terms such as good faith, public policy, fairness, etc. in statutes and by the judges in their judgments is based on principle of equity. The approach of judiciary in Menka Gandhi's case epitomizes the application of the doctrine. The Supreme Court in this case held, while interpreting word law used in Article 21 of the Constitution of India, that law must be just, fair and reasonable. In India, we do not have, nor did we ever have, separate courts as in England administering equity, but the equitable principles of law, that is justice, equity and good conscience, are the guiding force behind most of the statutes in our country and decisions of the courts. However, the importance of the concept has somewhat diminished from what it was in the 19th century. The diminishing effect owes its reason to the fact that the bulk of Indian law is now codified. Most of the law which came previously under the doctrine of justice, equity and good conscience has been codified by India, yet the bases remain the same. For example, in 1963, Specific Relief Act was passed by Parliament of India following the recommendation of the Law Commission of India and repealing the earlier Specific Relief Act of 1877. Under the 1963 Act, most equitable concepts were codified and made statutory rights, thereby ending the discretionary role of the courts to grant equitable relief. The rights codified under 1963 Act were as under: recovery of possession of immovable property mentioned under section 5 till section 8, specific performance of contracts mentioned under section 9 till section 25, rectification of instruments defined under section 26, recession of contracts defined under section 27 till section 30, cancellation of instruments under section 31 and 33, declaratory decrees under section 34 and 35. Injunctions are defined under section 36 till section 42 of the Act. With this codification, the nature of equitable reliefs available earlier have been modified to make them statutory rights and are also required to be pleaded specifically to be enforced. Further, to the extent that these equitable reliefs have been codified into rights, they are no longer discretionary upon the courts or as the English law has it. Nonetheless, in the event of situations not covered under the Act of 1963, the courts in India continue to exercise their inherent powers in the terms of section 151 of the Code of Civil Procedure 1908, which applies to all civil courts in India. There are no such inherent powers with the criminal courts in India except with high courts in term of section 482 of the Code of Criminal Procedure 1973. Further, such inherent powers are also vested in Supreme Court of India in terms of Article 142 of the Constitution of India, which confer wide powers on the Supreme Court to pass orders as is necessary for doing complete justice in all cause of matter pending before it. Dear friends, at the last but not the least, I would like to put light upon the Indian judiciary and British jurisprudence. For all its zeal to develop its brand of equity and justice, Supreme Court has not abandoned its habit of relying on English or any other legal system. We don't need to go through the cases law anymore for the immediate example, as is the euthanasia case, Aruna Schonberg's case, where the Supreme Court relied on English law among other legal systems around the world. The Supreme Court adopted and cited the Airedale case, where the House of Lords held that if a doctor acts on informed medical advice and withdraws artificial life support when it is in the patient's best interest, that action would not be regarded as a crime. Hence, it can be said that the dependence of the Indian judiciary on British jurisprudence has not disappeared to a large extent. However, the formula of the principle of justice, equity and good conscience is far from satisfactory, because the principle of justice, equity and good conscience does not have a clear and definite meaning. It does not apply to a specific legal entity. In short, it is the judge's discretion. This principle also opens up opportunities for judicial legislations from case to case. Moreover, applying laws developed in different climates and different civilizations thousands of kilometers away is pure nonsense. History is clear that Indian courts have refused to apply certain principles of English law. Even Indian courts sometimes apply English law, which is a result of peculiarities of United Kingdom. Together, justice, equity and good conscience form the basis of many legal decisions, particularly in cases where law is unclear or where the strict application of the law may result in an unjust outcome. In such cases, judges may use their discretion to apply these principles to arrive at a decision that is fair and just. For example, in a case where a person is facing eviction from their home, a judge may consider not only the letter of the law, but also the individual circumstances and whether it would be just to evict them. The judge may consider factors such as person's financial situation, their health and their family circumstances to arrive at a decision that is fair and just. Overall, justice, equity and good conscience are essential principles that help ensure that legal decisions are fair, impartial and just. By upholding these principles, societies can work towards creating a more equitable and just world for all. In the end, I would like to conclude by saying that equity, justice and good conscience in England developed in way back the 16th century and are working as a part of the legislature now. The importance of equity, justice and good conscience was greater emphasized than the common law system. During the centuries, it developed and gained importance in England and slowly it reflected in Indian legal system too. In India, it developed through various statutes and today several acts have been passed and are working by equity's principles. The legality of equity has radically gained significance in our recent years as well as in the past. In England, equity started to get less importance and it was then made a part of the legislature. Today, equity has gained importance in India and various acts work with its principles. So, dear friends, this was all about today's module. We will see you in the next module. Thank you very much.